Good evening and welcome to our second in the series of contracts and collaborations with Stanford Gould. If you're joining us this evening live, do press the like button and I'll try and say hi as your blue thumbs up comes across the screen. If you're joining us later on the replay, press like anyway, and if you'd like to add comments, questions, please do so in the boxes underneath and I'll try and answer them as we go along or afterwards when you come back to the live feed. So last week, if you go back to my page, you'll see the video. We talked about the broad structure of third-party suppliers to your business and who you might need a third-party supplier contract with. This week we're going to start to think about what's actually in these contracts and some of the really important terms that you need to get right and some of the pitfalls to avoid. So most importantly, to start, a contract that you're giving to a third-party supplier or an associate needs to state the status of the person that you are contracting with. It needs to say that they are not a partner, that they are not an agent, that they are not an employee, and that this is not a joint venture. Now, I should add straight away that just because a contract says that it isn't something, because obviously lawyers do not want you to be simple, we don't want anything to be simple, just because it says it's not, doesn't necessarily mean that you are completely watertight in describing someone as an associate, and I'll come on to why that's important in a little while. But what your contract needs to state is that they are not a partner, an agent, an employee, or that you're a part of a joint venture. And secondly, it needs to state that your supplier is responsible for their own tax returns and tax liabilities, and to get, if you can, what's called an indemnity from your third-party supplier, so that if in due course you are deemed to need to pay tax on behalf of that person, you can recover it from them. Again, I'll explain this in a moment. An indemnity is a legal expression for a promise that they will repay you anything that you pay out. Okay, so your contract needs to tell them what you're not. It needs to deal with who's paying the tax on this money, and in the normal course that should be the supplier. It can restrict what a supplier can do with other businesses who you might consider to be competitive. So you can have restrictions in a contract with a third-party supplier, preventing them from working for other competitive organisations, and you can certainly protect your information, your processes, your client lists to some extent with any restrictions that apply post the end of the contract with a third-party supplier. I should also add here that in a third-party supplier contract, the restrictions which you are allowed to impose are much broader than restrictions that you would otherwise want to impose if you were in an employee-employer relationship. The law that governs the restrictions in an employment contract is very different to the law that applies to restrictions in a third-party contract. So you can have some quite interesting restrictions to prevent a third supplier taking your client list and information about how you do your job and your trade secrets, another lawyer phrase, and using them somewhere else. So those are things to be important, that are important to be included in this type of contract. Now, you may say, Heather, right, we've set it out in the contract that this person's not an employee. We've set it out in the contract that they are paying their own tax. What else can it possibly be? Now, this is a complicated area of law and I'm giving you a real broad brush here, so be careful. Take this advice as that broad brush, okay? Whatever the contract says, it's the reality of what's happening on the ground which is what describes someone as either a third-party supplier or an employee. And the factors which are taken into control are essentially how much control you as the primary contractor have over your supplier or employee. Now, if you require them to work in a particular place, if you require them to work particular times, if you require them to wear a uniform, if you supply them with goods, tools, cars, vans, the kit to be able to do their job, these are all indicators that actually you are exerting control over this person, and therefore someone like the Inland Revenue coming to look at your operations may take the view, no matter what your contract says, this person's actually an employee. Now, the reason I referred to in the title to Deliveroo is that you might be aware that in the last 12 months or so there have been 2 or 3 very high profile court cases with employees from Deliveroo and also Uber, the taxi organisation, challenging whether they are in fact third-party suppliers, subcontractors, freelancers, or whether in fact they are employees. And the argument in those cases is all about how much control Deliveroo, let's use them as a good example, have over their workers. So if Deliveroo can require them to work at certain times, if Deliveroo are imposing a uniform, which they do, and they may provide vehicles, I do not know the answer to that question, but these are factors which in this particular piece of litigation, the workers are saying we ought to be deemed as employees, and from Deliveroo's perspective, suddenly you've got workers who are employed by you and are entitled to all sorts of additional benefits such as holiday pay, sickness pay, the right not to be unfairly dismissed, etc., etc. So the reason that this is big news is that these businesses have been structured in a way to call these workers subcontractors. Deliveroo do it, as I say, Uber do it. There are lots and lots of businesses who work on this broad structure. And there are lots of complex reasons why, as a business, you might want to choose that delivery method. But one of them is to avoid having lots and lots of employees who have rights and additional costs that you as a business might not want to incur. So obviously most people watching this are not running a business the size of Deliveroo or Uber, and probably you won't have the issues of using a subcontractor every day, all day, in a particular location with very specific instructions about what you are giving them to do and how they are to do it. If you are, you need to take some advice quickly. If, however, you are dipping in and out of the use of services, and we used last week the example of a web designer using a brander, someone who designs, someone who does the technical back end, where you're just using them on a job-by-job basis, quite unlikely to ever cause a problem, but in your contract, please make sure you set out those criteria. What they are not, what they are, whatever you call that, third-party supplier, subcontractor, freelancer, photographers that I work with like to call them second shooters, which I think is a great name for an operative. I'd like to be a second shooter, but I've no idea how to use a camera, as this probably demonstrates. So make sure you say what they are, make sure you set out what they're not, make sure you deal with the question of tax, and if you can, get an indemnity so that if someone comes in and picks all of this and you end up on the receiving end of the tax bill because they're deemed an employee, you need to be able to recover that money from them, or at least have the mechanism to do so. Whether they've got the cash, different question. And thirdly, think about what restrictions you might want to impose on a third-party supplier who might be doing exactly the same with another person to provide services to that person. So you need to be careful about perhaps some of the information you give them, who they use, what they can do. Again, this is really technical stuff. Take advice. Don't use one size fits all. Talk to someone about what's actually happening on the ground, what you're asking people to do, how you are asking them to work, and then make sure that your contracts reflect that accordingly. Okay, enjoy. I might go and order some Deliveroo. Maybe they'll bring it in an Uber. Who knows? But good to speak to you. I'll be back next week with my next instalment of things that you need in your third-party supplier contracts. Good to speak to you. Bye.